academic staff. So usually this is a week full of local on the ground actions and events and activities, but we know that with remote learning and COVID and the circumstances we're in right now, CAUT has organized a full week of online programming. So at the end of the session, I'll also plug a few more upcoming events for the week. Before we get going, I would like to take a moment to remind you that although this meeting is largely virtual, we all do our academic work on specific Indigenous, First Nations, and Métis territories. Some of these territories are governed by treaties, but some are still unceded. Today, I am participating in this workshop on the traditional unceded territory of the Algonquin Anishinaabe people. I would ask that you reflect on the conditions under which we occupy these spaces today and always. Before we get started, I'll also hand things over to my colleague, Justine DeJagger, CAUT's Education Officer, who will provide a bit more information on how we're going to proceed on Zoom.
Hello, everyone. So a note, as always, that we do have simultaneous interpretation available. It is just the globe icon on your toolbar at the bottom of your screen. Alors, nous avons de l'interprétation simultanée disponible. C'est l'icône du globe sur votre barre d'outils. And you just click on the language you would like to hear. So, alors, cliquez sur le langage dont vous voulez entendre. To participate in the question and answer period at the end of the session, you can either type your questions into the chat or feel free to raise your virtual blue hand and we will call on you to ask your question. To do that, to use your raise hand function, you click on participants, also on your toolbar, and then you should see a list of participants come up as well as the option to raise hand. It's a little we are recording today's session. We will be spotlighting the speakers who are providing the presentation today. But if you do not want to appear in the recording when you're asking your question, if you're asking a question, just remove your video and then it won't show up. That's it.
Thank you, Justine. Okay, so I'm very excited to introduce our speaker today, who is Dr. Samuel Trosow. Dr. Trosow is an associate professor at the University of Western Ontario, jointly appointed to the Faculty of Law and the Faculty of Information and Media Studies. Before going to Western, Trosow was a law librarian at the Bolt Hall Law Library at the University of California at Berkeley. And before that, he was in private law practice in California. His doctoral work in the Department of Information Studies at UCLA focused on information policy issues. Today, Dr. Trosow will be presenting on intellectual property in a time of remote learning for contract academic staff. So with that, I'll hand it over to you.
Well, thank you very much. It's always nice to be on a CAUT panel, and I'm glad to see so many people there. So actually, intellectual property is a much broader term. I'm just going to be talking about copyright. I'm not going to be talking about patents or trademark. Slide. So first of all, part-time academic staff are precarious enough in the face-to-face environment. And I worry that it gets even more acute. Many of the problems that we see are going to become more acute in the online environment. We like to call it the emergency teaching environment because I don't like to acknowledge that this is a permanent state of affairs, that this is just something we're doing under emergency circumstances. The importance of the contract is if you don't take anything else away from this presentation today, it's the importance of the contract, because the copyright rules that I'm going to talk about are largely default rules and they're definitional rules, but in terms of what your actual rights and obligations are going to be, in your situation, it's probably going to be under some contract or even a side contract. That's the most important point I want to make. The next most important point I want to make is when you're thinking about rights and obligations and exceptions under copyright, you have to separate out for analysis works. Works is the main subject area of copyright. But there are also other subject matters of copyright that we're concerned with, and that is what we call a performer's performance And to simplify this, the performance is your lecture. The work is your slides, your class notes, what you write. And the performance is your lecture. So we have works, we have performers' performances, and we have sound recordings. And typically a performance of a work is embodied in a sound recording. And as a practical matter, these three types of interests merge together, but it's very useful to think of them separately in terms of what rights you actually have, because they're treated separately in the Copyright Act. So I'm going to first go through the ownership of rights in works and the exclusive rights in works. What exclusive rights does an owner have in works? And notice when I'm talking about works, I'm not talking about the author. I'm talking about the owner, because it may very well be that the author is not the owner. And that's something we want to, as much as possible, try to avoid. Then I'll talk about the ownership and the rights in the performers' performances and the sound recordings. I'll say a little bit about moral rights, although I don't think I'll have time. I'll touch on infringement and fair dealing, although this presentation is not about users' rights. This presentation is not about what can you as an instructor do under fair dealing and other educational exceptions. This is about the ownership and control of your academic work. Slide. So I think I've said that. Slide. So the Copyright Act, and as much as possible, I'm pointing you to the section. So later on, you can go back and look at the section. The section will be reproduced in French as well. But the copyright means rights that are described in Section 3 for works, Section 15 for performers' performances, and Section 18 for sound recordings. As far as works go, the traditional subject matter of copyright, works can be literary, dramatic, artistic, musical, or some combination. Certainly you can embed art or music in a slide presentation, but I think just to keep this simple today, we'll think about a literary work that consists of a slide presentation. Now, when you do what I'm doing right now, and that is hopefully not just reading your slides, because there's no point just reading your slides, but you're embellishing them a little bit, you're using your slides as an outline, and you're giving a lecture, that would constitute in Canadian copyright law what we would call a performer's performance. And that is a separate interest from the copyright in the work. And then, like today's presentation, the performer's performance of a work, really a joint work, because we've already heard from other people. We're going to have questions from the audience, but it's going to be embodied in some type of, it's going to be fixed in some type of tangible medium so people can watch it later. And again, in reality, these different interests merge, but works, performances, and sound recordings are set out as separate rights. Can I take any questions on that? So you can change the slide. Okay, so I see chat. No, that's great to see everyone. Okay, so please, if you have a question, put something in chat right away. Yes, Barbara.
Sorry, thank you. I have a question. So I'm not lecturing online or necessarily, although a little bit. A lot of the time I'm curating, that's what I'm calling it, a series of resources and actions and engagements for the students. So I'm not performing, but I am compiling resources and putting them there for the students. Does that come under any of the categories that you've described?
Well, when we're talking about who the author of a work is, it's very possible that they're joint authors. You may play some role in it. And whether your contribution to the creative effort, whether your contribution to the original effort is enough to make you, to bring you up to the level of being a co-author, or whether you're not a co-author, really depends on a lot of facts and circumstances, which really can't sort through today. So the answer is maybe.
But in terms of how everything's brought together, that may, so in terms of how I bring everything together, that may or may not be my intellectual property.
It may or may not be. It might be that what you're doing is you're engaging with original with original contributions by putting things together into a compilation. It's very possible. Now, with respect to works, the owner of the work, their rights are listed in Section 3. Section 3 is a very, very long section. I'm not listing all the subsections, but the important rights here are the sole right. Sole right. Notice by sole, nobody else in the world has it. If you have the sole right, that is a monopoly. Everyone else in the world technically would need your permission in order to use it. Fortunately, we have doctrines like fair dealing that would ameliorate that harshness. But the sole right to produce or reproduce the work or any substantial part in any material form, and that's the copy. That's the copyright in copyright. And to perform the work publicly, substantial part of it in public. And also to communicate it to the public by telecommunication, which I think when you cause something to be sent over the internet, or if you fax something, or if you Zoom something out, I guess Zoom is a verb now, that would implicate Section 3, subdivision F, and to authorize any of those. Those are the exclusive rights in the works. Next slide. And then here's probably the most important slide of the whole presentation. Who is the first owner of the work? So basically what we have is we have this paragraph 13.1, which is simple enough. The author is the first owner of the copyright. And by author, we include poet, sculptor, musician, regular literary author, the creator, first owner of the copyright. Section 13, subdivision 3 is where we get into trouble, because there's an exception, and the exception is the employer owns it. Employment of some person under a contract of service, and the work was made in the course of employment. And there's a whole body of law that helps us understand whether something is done in the course of employment or whether it's done outside on your own hours using your own materials. For now, we're going to assume, just to keep this simple, we'll assume that the course materials that you create are pursuant to the scope of your employment. So absent an agreement to the contrary, it's the employer that owns it. So basically we have a rule, we have an exception, and we can contract out of the rule and the exception. And what we have to focus on, what you must focus on, this is the most important thing for you, is to focus on that agreement to the contrary. Because if you don't have an agreement to the contrary and you don't have other rights, there's a good chance that the employer is going to try to make a claim not only on the substance of your work, but the recording of your performance. And that is problematic. My desire here is to help you protect your ownership and control over your academic work. Generally, there's an understanding in Canadian academia that for academic staff, you would be considered the owner of that. But still, the written contract is going to be very important. Next slide. Now let's say that you own the work, and now we're talking about works here. You own the work. You can assign the work away. So you can own the work and assign it to the employer, or you can assign it to, if it's a journal article, you can assign it to a publisher. But it's important to distinguish between a license and an assignment. Think of an assignment as a grant of the ownership in the copyright. and think of the license as something much less than that. A license is not a grant of the ownership in the copyright. A license is just permission to use. So a license would give the user the right to use the work in a way that without that license, it could be considered a infringement. But notice in 13.4, it can be by territory, it could be by medium, it could be by the whole term or part of the term. So you can create you can slice that copyright right up into a lot of different interests. So it's not just a question of whether you give up your entire copyright or just part of your copyright, or whether you just give someone else a license. There are a lot of options here, and Section 13.4. I really recommend that you look at Section 13.4 very carefully later, because there's a lot of detail here that can affect you. Next slide. And in fact, I should say before I move out of Section 13, are there questions on Section 13? Yeah. I see a question down under chat. No, I don't. Okay. So if the first owner of a work is the author, the first owner of a performer's performance is the performer. That's you. Or someone you're working with. If it's a sound recording, it's the maker of the sound recording. In a lot of ways, the sound recording might be the most important thing, because that's the artifact that the work and the performer's performance is going to end up getting embodied in, that might become the subject of the dispute. Who is the maker? What the Copyright Act tells us is the maker is the person by whom the arrangements necessary for making it are made. And that may depend on a lot of different factors. I would say if you really want to try to make it more likely that you're the maker of a sound recording, you might want to consider recording some of the elements in a standalone program that you control, rather than doing it directly into the employer's WebCT or Zoom or whatever. And I know a lot of my colleagues like to create their own audio files before they bring them into their PowerPoint or before they bring them into their lecture. So there are a lot of definitions in the Copyright Act. I'm not going to go through all of them. While they define maker, they don't define performer. So it's not all that helpful. Let's go on to the next slide. If Section 3 tells us the exclusive rights of the owner of a work, Section 15 tells us the exclusive rights of a performer, the lecturer, in the performance, the lecture. And here's the really important one. You have the right to first fixation. The performer has the right to first fixation. And think of going into a concert where there's a sign up saying no recording, or maybe you're given permission to record, but you have the right, if it's not yet fixed, not yet embodied in some type of tangible medium, you have the right to communicate it to the public, you have the right to perform it, and most importantly, you have the right to fixation. Once it's already fixed, you would have the right to reproduce that fixation. Now, I'm using some complicated terms here, but basically, you would have the right to go into your classroom. If you're giving a regular lecture, unless there's some contract that says otherwise, you would have the right to tell your students, turn off your video, turn off your audio. I want to give this lecture without a tape. There are a lot of good reasons why an instructor, especially these days, might want to ask the students not to videotape. Now, the problem with that is you don't really know if the students are taping it or not, especially when you're online. And there are more and more add-ons. I understand that Microsoft now has a transcription add-on. It would be virtually impossible to really to really police students not taping. I'm less concerned about the students taping, because if I was going to, from the student's point of view, their taping of your lecture for their later personal use would probably be fair dealing anyway. Yeah, it would be. I mean, look at the way we take a very broad construction of fair dealing. So I think that would be fair dealing. What I'm more worried about is the employer taking it and capturing it and using it again. Because you come in under a contract, you give your best performance that you could possibly give, and bye, see ya, we don't need you. You've signed this away. Now, it might be, if you're talking about current events or context, it might change, but in a lot of the subjects we teach, it would be in the interest of the employer to save money to just sort of capture your performance. So you want to be really careful. You want to be really careful about that. You need to know if something's being videotaped or audio taped. You need to know that. And you need to have assurances from your employer that if the agreement is that you own the intellectual property in that performance, it's very important to know when and how it's being taped and for what reason that tape will be reproduced. So let's go to the next slide, and I think it's, yeah, and the exclusive rights in a, yes, your comment, Veronique. Yes.
Yeah, okay. Actually, there is an issue with student recording, especially in university, in department, where they tend to privilege students to give courses. So we teach students, they became our TAs, for instance, and then they are PhD students and they have the courses that we were teaching.
Yeah, and I would say that if they do that, it's gone beyond fair dealing for their own personal use and study while they're taking that course. And I don't know how you police against that. My other worry with having your lecture videotaped is more so in the United States than in Canada, but I think it's going to become a trend here. There are people that are going to go after you for what you say.
Oh,
And
yes.
there are things you may want to say in class, especially if you're dealing with sensitive material. I'm increasingly worried about attacks on the intellectual integrity of what academic staff say in class. And we see it already. We see it already in terms of some of these issues of freedom of expression.
Well, the University of Ottawa last week, a part-time prof had this issue with using the N-word.
Yeah, and it happens all the time. We see a big situation at Toronto. There have been problems at York. We could do an entire session on that, but there are really good reasons why you want to control that performance and that recording. Now, and that was a great question. Was a great comment. We could do a whole session on that. In terms of the exclusive rights in the sound recording that are held by the now maker of the sound recording, is to publish it for the first time, to reproduce it, and to rent it out, and to authorize any of those things. So I think we've covered, oh, there's one more slide before I sort of stop for a moment. Slide. Okay. In addition to the owner's economic rights in works and other subject matter, there's this whole other area of copyright law, and that is the author of a work has moral rights. The author has the moral rights, not the owner, because moral rights, and I don't have time to get into a long discussion of what moral rights are, but they can't be assigned. Unlike the economic rights, which we've seen under 13 subdivision 4, are very, very, very highly assignable. Moral rights can't be assigned. But in Canada, and this is really bad, they can be waived. And that's a problem. That really creates a problem for us. Because what you'll see more and more in these contracts, in these special contracts, is a waiver of moral rights. And just to give you an example, if you have moral rights in a work and in a performance, that would protect you from somebody sort of like chopping it up and just turning it into swill and just sort of like using just sending it out out of context. So the moral rights can be important, but the employers want you to will want a waiver of moral rights. And I see Barbara, question?
I don't have one.
I have a question. Veronique. Oh, this is from before. Okay, so these just haven't gone away from before. Sorry. Okay. Now, if you assign the economic rights in your work, say to the employer or the publisher, that does not imply an assignment. I'm sorry. That does not imply. Let me start that over. If you assign your copyright to the employer or to a publisher, that does not by itself constitute a waiver of moral rights. The moral rights would have to be, there'd have to be a separate, clear statement in the contract that you're waiving moral rights. And in addition to authors' moral rights in works, after 2012, next slide, we also have performers' moral rights in their performances. So Canada added this in 2012 to bring at least performances under some international obligations. And it's the same rules. The moral rights may not be assigned, but they can be waived. An assignment of copyright doesn't by itself constitute a waiver of moral rights. And in case you're going to do this by pantomime, this only applies to oral, A-U-R-A-L works. So you probably want to have some sound if you want to take advantage of this. This is a new section from 2012. Next slide. While today's talk is not really about infringement and defenses to infringement, you should know Section 27 says it's an infringement of copyright for any person to do without the consent, consent's the big word there, of the owner, not the author, the owner, anything that by this act only the owner has the right to do. Now that doesn't mean a lot by itself. If it's a work, you have to go back to Section 3.1. If it's a performer's performance, you have to go back to Section 15. But notice that Section 27 is your catch-all infringement section. It doesn't apply to just works. It applies to all the different types of copyright. And also fair dealing for purposes of research, private study, education, parody, or satire. Also news reporting, criticism, and review does not infringe copyright. And again, this is not just to a work, this is to all the different interests under copyright. So let's go on. I think at this point we're going to look at the contract. So before we do that, how many of you are under special contractual provisions that that govern the ownership and control of your work as non-tenure track people? I don't know how I ask a question like that in a class. Just hit your blue thing if you have some special contract. So I don't know if that's gonna work. I see nobody raising their hands. Does that mean I see a few of you? You're not sure? Okay. Well, okay. So Sarika has one. What does yours say, Sarika?
Hi, yes, I have written some online courses and I had to sign away all ownership of my intellectual property.
Did you waive more?
I don't think that was in the contract, but I have to say, I just saw that I really, really struggled, but as CAS, I didn't feel I had a choice.
Yeah, and I think these are increasingly common. And as we go into an online environment, and I think the universities are really going to try to take advantage of this, as people become less and less secure, more and more precarious, I think there's going to be more of a tendency for the employer to want to grab as many of your rights as possible. You know, for many years, they've understood this with patents very well. I mean, if you look in a typical collective agreement, you've got a very, very detailed patent clause. And they're starting to understand that more now with copyright. So this is something that will come up during contract negotiation. And let's see, did somebody else want to comment on that? So if you're not sure, you're going to go back and look.
Sorry, yeah.
My contracts just don't address it. There will be no existing course materials, yet no paid time. I don't know if I'm capturing that well. If you want to restate that, Adrian. Okay, actually go to the next slide and I'll come back to this one. Just go to the next slide. Okay, so basically the general rule under, no, go back. Stop. The general rule in clause 3 is a member is the sole holder of the copyright in their own lectures and in all copyrightable material. Yeah, so that's the general rule. Now go back to the last slide. I didn't put these in the right order. The last one, go back, stop. Okay, so copyrightable material includes, original works include, so you've got those recitals in the contract. So really what this turns on is whether or not the copyrightable work, the copyrighted work, is done in the course of the member's academic responsibilities. Because I can go home at night and write a series of poems or compose a musical work that has absolutely nothing to do with my job. And the good news is that would not be captured under any of the rights that this employer has. But the bad news would be I probably would not then, let me turn this up. I would not then be able to claim it on my annual performance evaluation. But is it done as part of your academic responsibilities? Now, if it is, at Western, at UWO, we are granting, this is all of us, we're granting the employer a 5-year, non-exclusive, which means we could do this with somebody else, royalty-free, irrevocable, and non-transferable license. So here you have a license, not an assignment. So even though the general rule is member retains their copyright, they are granting to the employer this very broad license, which is a permission for them to copy and or use such works in other teaching, research, and service activities of the university. And this is very typical. This is a very, very typical clause in a lot of contracts. When you sign up for Facebook or Twitter, or if you use scholarship at Western, which is just dreadful that this is in there, but this is a very typical clause that you're granting Facebook or Twitter or Reed Elsevier or whoever a non-exclusive, royalty-free license to do certain things. So it's really important to distinguish between copyright ownership, which can be assigned in whole or in part, and a mere, because it can be big, but a mere license to have certain uses. So go on to the next slide. So there are also other clauses where members can enter into side agreements with the university, with the employer. And this is, this collective agreement is only talking about the rights of members. So we have a lot of limited, we have a lot of academic staff who are just teaching one course at a time. And it's not regular over a period of time. The duties, it's not limited term, it's limited duties. And they may not have collected enough courses yet to even trigger their membership and their rights under the collective agreement. And in that case, you're in even worse shape, because whatever protections there are in the collective agreement would not apply to you yet until your membership is triggered. So in that case, you are totally, it's totally going to be based on what's in your contract. And there typically will be There typically will be a contract, and it will typically be very one-sided in favor of the employer. Now, I see this could be the silver lining for those of us not being paid for online development. Yes, if you have a separate side contract for online development, that is the most likely situation where the employer is just going to grab everything you do, and you keep nothing. Never thought about that. My contracts don't address it. There will be no existing course materials. This could be the silver lining for those of us not being paid for online development. The other thing I want to mention here, and I don't want to go into too much detail about what's in the UAFA contract. Could you go to the next slide? These side agreements have to have these terms. And you could see they've addressed the waiver of moral rights, which doesn't mean that you're waiving it. It just means the contract should address it. And believe me, if the employer is going to draft the contract and address moral rights, they're probably going to want to waiver. There are also separate clauses for commissioned materials. So if you go to the next slide, that means I just want to wrap this up and turn this back over to questions and comments. But don't get too involved in the details of the UAFA contract, because it's just an example. But if you are a member of your bargaining unit, you want to look at yours and understand what your rights and obligations are and what you have or haven't contracted away. And it might be that your collective agreement merely points to another side agreement that perhaps you entered into, or perhaps you're not even a member of the unit, in which case this doesn't apply to you, and you're just dealing with your side contract. That just sounds really confusing. So I think I'm going to stop and ask for questions. Yes, that's a really good question. Could I repeat the difference between the author and the owner? The author is the person that creates the work. You write the work. You compose the song. You draw the painting. You write the poem. You're the author. You're not necessarily the owner, because the author, the first owner, the author, the creator, can become separated from ownership two ways. First is if it's under 13.3, the employer might be the first owner. They owned it at the beginning. You never owned it. It's work. It's part of a terms and conditions of employment, and you've done it. The employer owns it. That's 13.3, which was on a previous slide. That's the first way. The second way is you're the first owner, but under 13.4, you assigned it to somebody else, not licensed. Because if you license it, you still own it. But if you assigned it, you've in all likelihood granted away your copyright interest. So there are two ways that the producer, that the creator can become, I'll say alienated. I think that's a good word, from the product of their labor, and that's through 13.3 and through 13.4. But the author retains moral rights. Does that make sense? Okay. Next question. Or comment, or just talk about the situation at your university. Adrienne.
Yeah, I just wanted to explain a little bit my comment there. We changed how our contracts are written up.
Could you speak up a little bit? Could you speak more directly in the mic?
They're continually changing our contracts. And the last iteration of our contracts didn't address ownership at all of materials. They're kind of designed as if you are just presenting existing materials and not creating at all. So I just wondered if anyone else had run into that, or how, because there is a need for materials to be created, and even if it's just a recording of a lecture or something like that. So, and as far as our membership in a bargaining unit, we are added into our bargaining unit, but it's basically through a letter of understanding that says essentially you're exempt from all of the sections of our collective agreement.
So does that negate a side agreement to the contrary, leaving you to rely on the default rules?
I'm not sure what you mean by that.
Are there contract terms that would govern the ownership and control over the work you over the material that you create, whether it's a work or whether it's a performance?
There isn't that I'm aware of. The contracts that I sign each semester are it's only like a paragraph long.
Okay, well that might be. I mean, I'd have to look at the situation at your university and look at your contract. I don't want to give you, I don't want to sort of tell you what I think that means, but that might be okay. But do you have a professional officer or somebody that looks at these for members?
Like as part of the union, you mean?
Yeah, as part of the association.
No.
Okay.
I am the representative newly, and I don't look at anyone else's contracts.
Okay, so let me ask the CAUT staff this question.
Yeah.
If a member has a question that they don't think they can get answered on their own campus, who would they address it to?
I think it would either be one of our collective bargaining officers who could help review contract language, or our legal department.
But feel free to contact me and I can point you in the right direction. education@caut.ca. I'll put that in the chat as well.
Okay. Sorry, that's Justine that was speaking? Yeah. Okay. Great.
Yes. So can you give a concrete example to help make the difference between economic and moral rights? Yes. Moral rights would be, I'm going to use art here. I'm just going to use the painting. Moral rights would be somebody defaces the painting, draws a mustache on your painting, or covers it up in such a way as to damage your integrity and honor as the painter. That would be moral right. So we hear a lot about musicians, composers complaining about certain people using their songs. That would be in Canada. That would be a moral rights violation. Even though you have in Canada, even though you have a license to play my song at your rally, I haven't waived my moral rights, and I'm going to stand on my moral rights. And that would work. That would work. There's very little case law in terms of moral rights. The economic rights, that would go through a contract. They would go through a license. If it's a musical work in Canada, it would probably go through the SOCAN license. But unless there's something clearly set out in the contract where you've waived your moral rights, you still retain your moral rights. I don't know if in terms of a work, it would be cutting it up in such a way as to taking your name off of it. One of your rights is to attribution. One of your moral rights is attribution. Taking your name off of it to your prejudice. To your prejudice. It has to be prejudice for moral rights. Does that? I hope that helps. How do we respond to people who say they're not selfish, they're thinking of the students, they give their material? Think about the students all you like, but like worry about your employer. You know, I'm not talking about our rights vis-a-vis the students right now, which I think we have to concede that at least the student that's acting in good faith to make material available for their private study in order to get through the course, we would certainly argue that that's fair dealing, vis-a-vis a claim from a publisher or for the institution. My worry is not our relationship with our students so much, but it's our relationship you know, not just with the employer, but with these educational technology, these private firms that are providing educational technology services to the employer, who maybe want to grab some aspect of your of your rights. So I think that the way you show you're not being selfish is you say it's a matter of the integrity of the educational process for me to be assertive of my rights here. And I will bend over backwards to make my material available to learners and to students. But I can't just sort of, if I took all of my work and put it in the public domain, then any company would be able to just reproduce it without paying me. And that's not good. Yeah. Yeah. You have to be assertive. If you don't assert your rights, nobody's going to assert them for you. And these are rights that are worth asserting. Which puts me in a strange position, because when I'm talking about copyright, I'm usually talking about why fair dealing should be very broad, and why we should have a very, very broad and expansive fair dealing. But here I'm wearing a different hat, and I'm talking about the rights of the creator. And I think those two worldviews are very, very consistent, because we never argue that copyright should go away. We argue that copyright should be a balance. And here's the other side of that balance. We still have a good 10 minutes. I'm hoping that there are some more questions or comments. Are there issues that come up that I haven't addressed that we could talk about?
Could I ask another question?
Yeah, sure.
Thank you. And thank you so much for this. It's really, I mean, I think, I don't want to speak for everyone, but myself, I'm like, oh, there's a lot of questions. There's a lot of follow-up I need to do. So I'm really, really happy and grateful for this opportunity to be shown some of the questions I need to ask. But with respect to online course development specifically, which may not involve recording lectures, which may not involve sort of, my face-to-face teaching is substantially different than my online teaching. Are there any new, or are there any new developments in examining copyright for folks in this position? I guess is what I'm curious about, that are sort of responsive to what's happening in online teaching.
I think for the most part, we are trying to take the rules that have long developed in the face-to-face physical world and just have them imported into an online environment. And in the context of what's fair dealing, what we can do in our class, I take the position that the doctrine of technological neutrality, which is from a Supreme Court decision, says that you should reach the same result across a variety of different platforms, and you shouldn't reach a different result in one area that you wouldn't reach in another. So a lot of the things that we can do in the classroom, in the library, we can't do in the online environment. Students can't walk into the library and consult with reserve materials. So we have to be creating digital alternatives for them, which may put more pressure on fair dealing. And some universities are very adaptable to this. Other universities, including mine, is just, whoa, we don't want to annoy the publishers. And it's very difficult to get any kind of serious movement. So we're not learning a new set of rules in the online environment. We're just trying to adapt what we already know about the print world and the face-to-face lecture world to the online environment. And given the importance of technological neutrality, we want to be as true to the regular rules as possible. So don't let an administrator tell you, oh my God, it's a pandemic, it's an emergency, we have to be doing all these things, and you can't be doing that, and you can't be doing that, and we're going to grab this stuff. You want to try to be consistent and apply the rules that you have already learned in the physical world.
Thank you.
That's a very good question.
Can I give a follow-up? Sorry, if no one
Please.
else. Oh, I see someone else has one, so I don't want to take up the space if you want to.
So if my employer is encouraging the pre-recording of my lectures, their uploads into my sessions, it's to my benefit to upload recordings from a non-institutional platform. Yeah, the problem with that is, in order to deliver it to the students, it's going through the institutional platform. And while you can remove them and retain them yourself, you might not want to deprive your students of ongoing access to them. I mean, for me, the challenge is, how can I make sure that my students continue to have access to this material? And I know this is going to sound terrible, but not my employer. That sounds like it's a game, but I think it is to your benefit to create, and you know, we all have different levels of production skills, but to create at least sound recordings using your own independent program and keeping custody and control over the original that you then just sort of move in and out of your platform depending on where you are in the class. It's probably creating more work for you. And notice that these handy educational technology tools that our employers not only make available for us, but they pretty much mandate that we use. We have to use OWL. It's very difficult. I mean, I used to say I'm not going to use OWL for this course. It's very difficult to do that now. It's very difficult not to use Zoom. There are a lot of problems with Zoom. And the university, of course, will say, oh, you don't have to use Zoom. There are all sorts of other Teams or whatever programs you can use. You don't have to use Zoom. But if you go into OWL, there's a link for Zoom. I mean, they want you to use that, and they make it really hard for you to not use the tools that they make available for you. Do the students need to have access after the session? Well, I mean, I think you should give the students access after. That's up to you, but you want your students to be able to refer back to the materials to study. I mean, your purpose for doing this is to teach, and you're concerned about the ability of students to learn. I don't want to be judgmental about how much you share or don't share with your students. That's up to you, but especially if you're going to rely heavily on fair dealing to be using excerpts from other things, you should probably be consistent.
I'm not seeing any other questions. I will give one more minute if anyone wants to raise their hand using the participants function or type a question to the chat. And if not, I think we will wrap up. I will note that the session was recorded, so I know there was a lot of information that was walked through. Thank you so much for your presentation. That the session will be circulated and uploaded to the CAUT website in the next week or so. So I do encourage folks to review it again and share it with others. I know a lot of folks were hoping to attend the session, but are teaching right now. And so to make it as available as possible, I think it's been a lot of information that will be very, very valuable to a lot of folks. So with that, I'm not seeing any other questions. So I would like to thank you very much, Dr. Trosow. That was really informative. I just texted a friend going, I didn't know copyright was this interesting. And I would just like to plug a few Fair Employment Week events that are happening for the rest of the week. So the first one is tomorrow at the same time, 1 p.m. Eastern. We have our keynote address for the week. Dr. Liz Morris, who's a UK independent scholar. Her presentation is titled A Plague on Universities, How the Pandemic Has Created Breach Points for the Future of Labor, Pedagogy, and Values in Higher Education. So again, that runs same time, 1 to 2 tomorrow. And then on Thursday, there's no Zoom event, but we're encouraging folks to engage online for a social media day of action. So CAUT will be circulating and sharing on our Twitter and Facebook social media shareables. We encourage other folks to share. their experiences as contract academic staff to encourage students to share the impact contract academics have had on their education, and really get that trending on Twitter using all of the social media terms. And then on Friday, we're hosting an informal Zoom social for contract academics specifically. So that's again from 1 to 2 p.m. Eastern. And we're just going to open up a Zoom and folks can have conversations. We'll do breakout rooms. There'll be some discussion questions, but mainly it's an informal space for community building and networking. So with that, again, thank you everyone, and keep an eye on the CAUT website and your email for the recording. And thank you again, Dr. Trosow.